Let's proceed. Yes.
Good morning. May it please the Court, my name is Andrew Pallid, and I represent the Libertarians. The issue before the Court today is whether Chapter 53, Section 14 provides minor parties like the Libertarians with the right to substitute the presidential and vice presidential candidates listed on their selected at their nominating conventions for those listed on their nomination papers. This is a matter of national importance because without this right to substitute, minor parties like the Libertarians are forced to hold their national conventions and finalize their presidential and vice presidential candidates as early as February or risk having those candidates left off the ballot altogether.
Let me ask you a couple questions. Who is the candidate for state office? Is it the elector or is it the presidential and vice presidential candidate?
It's the candidate for presidential elector.
Well, how do you square that with the language of the statutory scheme? Isn't it the elector who will be casting the vote, in fact, in the Electoral College?
That is correct.
And don't you have to list those people on the nomination papers?
You do have to list the presidential electors.
And did those people change from, were you seeking to substitute them?
Yes, in effect, they were substituted so that the vice presidential and presidential candidates could be substituted.
So they were different electors?
Absolutely.
Could they be the same?
I don't believe so because I believe an elector has to pledge to support specific presidential or vice presidential candidates.
And change the pledge?
I don't believe that that would be allowed under the statute.
Now, you call yourself a party, but you're a political designation as far as the secretary is concerned. What is he supposed to do? You said you declare that a convention has made a nomination, and I'm sure it did, but how is he supposed to distinguish between 10 people in Fargo, North Dakota meeting and saying, we do this? I mean, how is he supposed to know this is a convention that has the imprimatur of a party, which should be viewed as the equivalent of a Democratic or Republican convention?
Well, first of all, I don't think that that's an issue under the facts of this case, because the Libertarian Party is the third largest party in the nation and holds a national convention with delegates from every state in the country, which they attend that. So that's not really an issue before this court or an issue in this case. However, the real issue is whether or not the Libertarian Party or the minor party can fill a vacancy when a candidate for presidential elector withdraws under Chapter 53, Section 14. Someone has to be able to fill the vacancy, and it's either going to be the minor party or it's going to be the 10,000 voters who sign the nomination papers. The 10,000 voters who sign the nomination papers can't fill a vacancy. It would be impossible, because you have to fill a vacancy within 72 hours after a withdrawal. To have 10,000 people get back together, recirculate new nomination papers, re-sign new nomination papers with substitute candidates, it would be impossible. The Secretary admits it would be impossible.
But that's not what the Secretary says in his letter, right? It says you have 2 months that you can do this.
The Secretary's letter states that the Libertarians in this case, because they held their convention at the end of May, they had 2 months in which to circulate new nomination papers with the candidates named Barr and Root on them.
What's wrong with that?
Well, what's wrong with that is that in this case, the Libertarians happen to have their convention at the end of May. However, in 4 years, they might have their convention at the end of July, and then they wouldn't have enough time to substitute. And in the past, minor parties like the Reform Party and the U.S. Taxpayers Party have held their conventions as late as August. So this issue occurs again and again. And
well,
just
if you're going to be a party, isn't there another way to get on the ballot more regularly without having to go through this?
Well, there are two means of becoming a recognized political party in Massachusetts. One, you can have a candidate on the ballot that garners at least 3% of the vote in a statewide election. Or two, you can gather 1% of the electorate and have them register under your political designation. The second manner has never happened in the Commonwealth, as far as I'm aware. The records dating back to 1948 show that no political designation has ever become a political party by registering 1% of the voters in Massachusetts. So the first method of getting on the ballot, having your candidate garner 3% of the vote, seems to imply that it is the minor party's candidate that's on the ballot from the nomination papers. Otherwise, why would the minor party be rewarded with the status of recognized political party when the candidate garners 3% of the vote?
Could an individual and not a recognized, an unrecognized political designation also run for president?
That's correct. Yes, they could.
So is their status any different, the individual, or, I mean, the political designations cover the whole spectrum, right? It's not,
They don't cover
just minor political parties.
Well, that's not correct. Individuals who run as independents can't choose independent as a political designation. They just don't list anything next to their name.
So political designation just means what sort of
Political
group?
designation is really almost like a party in waiting designation, because
Is it defined that way?
it's defined as it's defined in terms of what the political designation needs to do in order to become a recognized political party. They can have a candidate that garners 3% of the vote, or they can register 1% of the voters under their political designation, which makes it seem like a political designation is really just another word for a party in waiting or a minor party.
But if you take the individual also has to, could get 10,000 signatures and get on the ballot, correct?
Are we talking about an individual as an independent or an individual who has identified themselves with a political designation?
As an independent.
As an independent, yes, absolutely.
Okay, so, okay, but that person's not going to change his or her mind, so that's not the problem.
Well, if that person does change his or her mind, they can simply withdraw under Section 13, and presumably they wouldn't want to fill the vacancy after their own withdrawal.
Right.
But it sounds as if you're trying to get the benefits of being a political party without having earned it at the ballot box in the previous election.
We're not trying to get the benefits of becoming a political party. We're only trying to get the benefit of being able to fill a vacancy and substitute a candidate. And that's it. We're not asking
But that's reserved for political parties.
Well, if you read the statute that way, then yes, it is reserved for political parties. But if you read persons who made the original nomination to refer to the minor party that requested the nomination papers, that placed the candidates' names on the nomination papers, that collected the signatures on the nomination papers, and that filed those nomination papers with the secretary, then persons who made the original nomination refers to the minor party, and the minor party should have a means of filling the vacancy under the statute.
One of a recognized party now doesn't have to go through this signature gathering at all.
No, they don't.
So how do the names of the recognized parties get on the ballot?
The recognized parties, the Democrats and the Republicans, on the second Tuesday before the election, they send their candidate names for president and vice president on a form to the secretary, and they're afforded automatic ballot access. So that would be one of the rights afforded to a recognized political party that would not be afforded to a minor party like the Libertarians.
So even if you had this right of substitution, you
with the right of
still have to get
substitution.
10,000 signatures, you still have to do that.
That's correct.
Now, the people who were originally running in Massachusetts on Libertarian designation, Phillies and Bennett, and they had gotten the correct number of signatures, and they were all squared away. The national convention happens, and suppose Phillies and Bennett don't want to withdraw.
If Phillies and Bennett don't want to withdraw, then the Libertarian Party cannot force them to withdraw under Chapter 53, Section 14. Only when there is a withdrawal is there the question of who gets to fill the vacancy.
So could a recognized political party just do a substitution without the consent of the?
No, the answer to that has to be no, unless this court finds that there is a right to substitute under Article 9, and that right to substitute includes the right to force candidates who the Libertarian Party does not back off the ballot. And that's not what the Libertarian Party is asking this court to do in this
I
case.
appreciate that that's not what it's asking us to do, but I'm just trying to understand how the statute works.
So generally, under the terms of the statute, if Phillies and Bennett had not wanted to withdraw, then there would be no vacancy to fill under Chapter 53, Section 14, and therefore there would be no question as to who gets to fill the vacancy, and they would just appear on the ballot with the designation Libertarian.
My question, though, I guess, is if the Republicans had a place filler, basically, in Massachusetts until the Republican National Convention took place, and the Republican National Convention nominates somebody different than the placeholder, can the Republican Party come in and say, we want a substitute?
They don't have to, though, because they don't have to file anything till September.
Yeah, they don't have to file anything
They
until
don't have
September.
to do anything, but suppose they did.
Suppose they filed something before September, could the Republicans substitute? The Republicans, I believe, have
Does it
additional
rest
rights.
within, I guess my question is, does it rest within the party, the Republican Party, to designate who it is that's going to be the Republican candidate?
I believe that the Republicans have a federal constitutional right to determine which candidates of theirs appear on the ballot, so they would necessarily have the right to substitute, even if that right wasn't afforded to them under the terms of the statute.
Okay, and you're not claiming the same for the Libertarian Party?
We're not claiming the same for the Libertarian Party in this case, under the facts of this case.
Could I ask you, I'm just trying to understand the statute. I'm looking at the first sentence of Section 14, and after the semicolon, so it's addressing if the withdrawal happens and the time is insufficient to do it the same way.
Yes.
And it says, if the nomination was made by a convention or caucus in such manner as the convention or caucus may have prescribed. So couldn't the Libertarian Convention say, do something about that?
I think that the Secretary's reading of that would be that the Libertarians' initial nomination was not made by convention or caucus, but rather by the submission of nomination papers with 10,000 signatures, and therefore, because it wasn't made by convention or caucus, Phillies and Bennett, they chose their names before there was any convention or caucus, and as a result, that provision wouldn't apply to the Libertarians.
And this year, when is the convention?
The convention this year is May 5th and 6th, I believe, so they moved it up a little bit in order to provide themselves with additional time.
Just in case.
Yes.
And is part of your argument, obviously the First Circuit did not agree with your equal protection argument.
That's correct.
It's a matter of federal law. And I know you make an argument under the state constitution, but is it also under the state equal protection clause, or is it really the Article 9 or whatever?
Our complaint is restricted to Article 9, and our argument is that Article 9 provides greater ballot access rights than are guaranteed by the 14th Amendment. And this court has previously interpreted the Massachusetts Constitution to provide and guarantee greater rights than those guaranteed by the federal Constitution. And in Batchelder, this court has actually read Article 9 to guarantee greater ballot access rights than those guaranteed by the 14th Amendment. So, returning to the question of who gets to fill the vacancy, if there is a vacancy under Section 14, as we see it, there are two options. Option number one is that the persons who made the original nomination refers to the 10,000 voters who signed the nomination papers. That would be impossible. Vacancies could not be filled if that's how the statute was intended to be read. The other option is that persons who made the original nomination refers to the minor party that actually got the nomination papers, put the candidates on the nomination papers, circulated them, and filed them with the secretary.
Well, how about then that minor party, when it wants to substitute, if the time is permissible, as it was arguably here, you had 2 months, it's the Libertarian Party who can then go out and gather 10,000 more signatures for the names of the people that it wants to have on the ballot.
That wouldn't really be the right to substitute or even the right to fill a vacancy caused by withdrawal. That would just be starting over. That would simply be...
in the same manner it was done the first time.
Well, the Secretary's position is that you can actually only withdraw 72 hours after the deadline for submitting nomination papers, so it wouldn't even be possible to recirculate new nomination papers, and you would have...
But let's say that reading is not one we adopt. Let's say we say what apparently the Secretary said here, which was that you had 2 months that you could do it.
The question, as I understand it, is that... The issue, as I understand it, is not, that wouldn't be an issue of substitution. That would simply be an issue of, is there enough time under the Constitution to circulate nomination papers and collect signatures? And that doesn't really have anything to do with the interpretation of Section 14, but that has more to do with whether or not Article 9 provides a right to substitute.
So if I understand what you're saying the language "or persons who made the original nomination," if it doesn't mean party, it does mean the people that signed the nomination, the petitions, and that's impossible. So you can't fit it into the statute. To do what Justice Lang is saying doesn't fit within the statutory language. It's just outside of the statute. It's another method.
That's exactly what I'm saying.
Thank you, sir.
Thank you.
Good morning. Excuse me. Good morning, Your Honors. It just makes no sense to assume that the legislature would have intended to allow non-party candidates to circumvent the only mechanism that's in place to ascertain whether those candidates have established demonstrable public support. And therefore, this Court should reject the Libertarian Association's statutory claim of substitution for exactly the same reason that the First Circuit rejected their equal protection claim, namely that it would result in an end run around the signature requirement.
But would you agree, though, that that the idea of getting new signatures doesn't, maybe it's required, but it does not fit within the statutory language?
Well, yes, we agree. It would be physically impossible to get new signatures after the filing deadline. In time to
No. I guess what I'm asking is, let's assume just that there's physically time. I mean, let's just say here, the convention is in May 5th. Secretary says you've got 2.5 months. You've got 3 months to get signatures. Maybe that's what they have to do, but that's not because it fits within the persons who made the original nomination, is it?
Yes, and I'm sorry if I misunderstood your question. There clearly is enough time. As happened in this case, there will be in 2008, there will be even more time in 2012. That time frame that Your Honor just asked about is the time frame prior to the filing deadline in late July. That's the deadline for filing.
So it's really like starting, as Mr. Pallett said, it's starting over again. It's not a substitution in that.
Well, let me see if I can make my point more clearly. The Libertarians, or anyone for that matter, can start collecting signatures as early as February. The papers will be coming out this year on February 14th. And in fact, they could collect signatures on behalf of multiple candidates at the same time, should they wish to do so, and then just wait to see who is lucky enough to get the endorsement of the convention. The point of the First Circuit's decision and our position is that either starting in February, or should they want to wait until after the convention if they choose to do so, regardless, there's enough time between either of those two starting points and the late July filing deadline that's been held constitutionally permissible in the federal litigation. What they're asking for is, after the filing deadline has passed, they're asking to now have the chance to substitute their convention-endorsed candidate. And by the way, the word convention is a bit of a misnomer here. We used it for convenience sake, but the Libertarians are not a party. There is no meaning to the word minor party. They're not even a political designation. A political designation is, although the statute could certainly benefit from a more artful language, but a political designation is simply a label of 3 words or fewer that can be used by a candidate, by an individual candidate, to describe their particular viewpoint. And the Libertarian Association doesn't control the use of that label, as is vividly illustrated by another First Circuit case, the Gardner case in New Hampshire, where both Barr and Root appeared on the New Hampshire ballot under the Libertarian label, as did Phillies and Bennett. And that same exact scenario is possible here in Massachusetts. So they don't, even if a Libertarian Party springs into being, the people who control the Libertarian Association don't necessarily become the leaders of the new Libertarian Party. State law requires that voters elect members of a state party committee. And so it could well be these Libertarian Association people, but it could be another strain of libertarians or yet some third entity, if the prerequisites for becoming a recognized party were to occur. But the point is that the Libertarian Association has no legal status in Massachusetts.
A political designation, then, in your view, is the same as an individual candidate?
A political designation is a term of art that really just refers to a
Putting a label by your
putting
name?
a label by your name should you decide that you want to describe yourself in that manner. It's not required.
But it is for an individual candidate to determine the content of the label.
That's exactly right, as long as it's 3 words or fewer and it does not use one of the words of a recognized party.
So, but isn't there some kind of implicit suggestion in the statutory scheme that there is a group identity lurking someplace, and that group has the possibility of becoming a recognized party? It's not, it doesn't seem to be just about individuals.
No, I think that's incorrect, Your Honor. Except for recognized parties, there are only individual candidates, and the only way to the ballot is for an individual candidate to gather and submit 10,000 signatures. And the fact that the voters are nominating and signing those papers for an individual candidate is reflected in the statute itself, which requires in Section 8 very, very specifically that the names and addresses of each candidate be identified on the nomination
That's
papers.
true for those who are nominated by the parties, too, isn't it?
No, because
That identification of candidates and electors?
they don't have to, the recognized parties don't have to go through the process for the presidential candidates of submitting the nomination papers. So the state party committee, for example, of the Democratic Party forwards in early September to the secretary a list.
But all the same information, right?
I honestly don't recall whether that, but the point is that and in fact, the statute, Section 8, actually prohibits the circulation of nomination papers in which there is not listed the required information, that is the name and address of the candidate.
So if for any word of description after the candidate's name, none is required. This person could just go on the ballot as John Doe or Jane Doe.
That's exactly right.
And if the person is the nominee of the Democratic Party or the Republican Party, not that they're going to do it, but can they also go with just their name, or do they, if they're the nominee of a recognized party, do they have to put the name of the recognized party after the name?
No, the recognized party name does appear on the ballot.
It has to appear that way.
Well, probably the party
I mean, you wouldn't
insists.
want to do it
Probably
any
the
other
party
way, but
insists, yeah.
Yes, it's only a political designation is not a mandated. A person can either, an individual candidate can choose to self-identify themselves by any 3-word label, but they don't have to do so. If they do so on the nomination papers, then that 3-word or fewer label accompanies their name on the general election ballot.
But if Mr. Barr had run as an individual and got 5% of the vote in 2010, there would be no Barr party that would exist because he ran as an individual, correct?
That's correct.
But if he ran as a libertarian political designation, then that political designation would become a party.
No, he could be a party, couldn't
Yes,
he?
I want to be very specific. That name, that is the name that he chose for his political designation, would become the name of a newly recognized party, but...
The Barr Party?
Yeah.
No, I'm sorry, I misunderstood.
The
I thought you
libertarian.
said...
It would be if he ran as a libertarian, it would be a
used-
libertarian party.
Yes, excuse me, Your Honor.
So
If he used
the name has name has consequence. It's not merely that the name can become a party if he gets enough votes.
The name can become the name of a recognized party, but the leadership and governance structure of that newly recognized party is then governed by other provisions in the statute which require that the voters elect the state party committee. So again, the fact that the Libertarian Association happens to have used some of its resources to back a particular candidate, if that candidate garners 3% of the vote, having used the word libertarian, And if a new Libertarian Party then springs into being, the persons who run the Libertarian Association do not necessarily become the leaders.
So this happened before, yes? The Libertarian Party did get more than the required percentage, and were they on the ballot the next time?
A particular candidate,
Yeah.
I think it was a U.S. Senate candidate, did garner.
More than 3% in a statewide vote?
Yes, that's correct.
So then what happened?
And then I believe that the Libertarian Party lost its party status because no candidate even appeared on the ballot under that.
Okay. But they would have to have done more. They would have to have now set up a structure that satisfied Massachusetts law about sort of electing members of the party and leadership of the party in order to get on the ballot. So it's not just getting 3%, it's then all these other things?
Well, these other things are requirements and ways that the party can govern itself. But I think in this
But it would
case,
have to have done that between Election A and Election B in order to carry over that Libertarian name as a...
well, they have to, I think actually the more pertinent requirement that has to be met is that a recognized party has to retain its established public support, so that if...
Wait a second, they got 3%. So what does the 3% get them? They got 3% in the last statewide election. That gets them what in the next election?
Well, I don't believe it gets them anything unless they continue to...
So they have to do the 10,000 signature thing all over
Oh,
again?
no, I'm sorry, I misunderstood. Once a party becomes a recognized party, if it decides to field candidates, its candidates, the state party then holds a primary and can winnow down for example, in the Democratic
And it becomes a
Party.
recognized party by getting 3% of the statewide vote and something else?
No, there are two ways. One way is if a candidate garners 3% of the vote, or if, I believe, 1% of the voters register under a name. That's the second way that an entity can become a recognized party.
So if individual identifying himself as part of a group, though,
I'm sorry, I didn't
it's
hear
the individual candidate identifying himself as part of a group that then, as a result of his having gotten 3% of the vote, allows the group to become a recognized party.
Well, it allows the use of, in this case, the Libertarian label to become the name of a recognized party, the structure for which then has to be selected by voters. And this is important because the bottom line is that the Libertarian Association has no legal authority in Massachusetts to represent the 10,000 voters who signed nomination papers supporting Phillies and Bennett. In fact, Phillies and Bennett were reported to have philosophical differences from Barr and Root. It's certainly reasonable to assume that those voters would have been quite surprised, if not upset, to know that their signatures were being transferred to another candidate. But we don't know who the Libertarian Association is. We don't know how it chooses its delegates to its convention. We don't know. There's no legal assurance that it reflects the will of Massachusetts voters. That's the key difference between something that's not a party and something that is a recognized party. Again, because in the case of a recognized party, the party committee is elected by the voters, state law ensures that the recognized parties do reflect the will of voters. They've also, of course, in order to become recognized parties, they have already demonstrated substantial public support. So in the case of non-parties or anything else other than recognized parties, you don't have that legal assurance.
Now, the consequence is that if we had a time back in '92 in which Mr. Perot arguably could have won, if his vice president were to die in September, he's out because there's no way to replace him after July 31st?
You're speaking of not a recognized party candidate.
I think it was called, I forget, the Reform Party, I forget what Perot called his party, but at one point he was ahead. Well, if his vice president had passed on after July 31st, according to you, there's no way in which he could have remained on the ballot?
I honestly don't know the answer to that question, but I think that what that highlights is that that's a sort of exigent circumstance that is not present here. Here, the Libertarian Association is essentially attempting to seize on a statutory provision that has nothing to do with getting ballot access in the first place. It's meant to address the unusual circumstances when something unexpected occurs, like the death of a candidate or a withdrawal after the nomination papers are filed. It's not a means to obtain ballot access in the first place, again, for the same exact reason that the First Circuit rejected the constitutional claim, finding that it would effect an end run around the signature requirement. So, too, the substitution that they are seeking under the statute would completely circumvent the signature requirement.
So you would leave open the possibility that if the Libertarian Party were to nominate somebody who would get 10,000 signatures and then that person were to pass on, that the Libertarian Party could arguably replace that person?
No, I'm sorry, I misunderstood your question. No, because with anything other than a recognized party, the candidate, it's individual to the person. And so the nomination papers are signed to signify support for the particular candidate, whether it were Ross Perot or Bob Barr or George Phillies. And so if that person dies, if it happens before the filing deadline, libertarian-minded persons in the Commonwealth could certainly obtain 10,000 signatures for a different candidate.
If it happens after, they're out of luck.
They're out of luck, yes.
Thank you.
Thank you.